Hello everyone, I'm Viv Coles and I'm a senior finance caseworker. I'm based in the Cardiff office. I've worked for the LAA now for around 13 years, starting with a short stint in our admin support team, and then I moved on to the civil billing team, where I process most types of bills, family and non-family, and I also deal with appeals and any sort of inquiries, so billing inquiries, that sort of thing. So that's me. So today we'll be looking at some specific aspects of non-family billing. But before we do this, we thought it would be really useful just to give a quick overview of non-family cases and some general points on billing them. What we won't be covering today is cases where costs have been recovered and or damages have been paid to the client. Obviously, that's a little bit more of a complex area. We'd envisage there'd be quite a lot of questions around those subjects. So we've actually going to be having a separate webinar, and that's been arranged for later in the year, and a communication will go out to you to give you details and the dates for those webinars. Okay, starting on slide 6 then. First of all, you'll see a table in that slide that lists all the various non-family proceedings, and it has a link there to Appendix 2, which basically covers those proceedings, and that's in the electronic handbook. We won't be covering proceedings that fall under court of protection and or mental health today. There is, I understand, a webinar being arranged again for later on in the year, and communication will go out in relation to that as well nearer the time. You'll see in the slide it does mention antisocial behaviour, crime and policing act proceedings, and they're paid at hourly rates under table 10A of the remuneration regulations. And just to point out there, where work relates to a breach of the injunction, if you're representing your client on the breach, then a new claim would have to be made, because it then falls within criminal work and fear of representation order. So it will then come under criminal legal aid. Moving on to slide 7 then. Unlike family cases, there are no fixed fee schemes. All work for both solicitors and counsel should be billed at hourly rates. The applicable hourly rates for solicitors can be found in the Civil Legal Aid Remuneration Regulations 2013, Schedule 1, Part 3, Table 10A. And the applicable hourly rate for counsel, including rates for senior court, so that'd be sort of like the Supreme Court, Court of Appeal, can be found in the Civil Legal Aid Remuneration Amendment Regulations 2013, and that's Schedule 2, Table 1 and 2. Solicitor and counsel claims need to be submitted together, as they need to be assessed together, and I'll be talking about that more specifically in the next section. We have a top tip on that slide there. So whilst we don't generally require a full file of papers on each case, you must ensure that evidence of all the work that you're claiming is on your file. Even where a claim is paid without file, of course, file may still be post-payment required for auditing purposes. So it's really important for every item you bill, you must have evidence on your file. So moving on to slide 8 then, where the total assessable cost of a claim, so that's profit costs, disbursements and counsel fees together exceed £2,500, your claim meets the court assessment threshold in that instance. Now you can choose to have them assessed by the court or submit them as a voluntary assessed claim to the LAA. However, you choose to submit them as hourly rates claims, then that would have to be billed line by line. The exception to this is where there are disputed inter partes costs. In this instance, the cost must be assessed by the court, and we've added a link to the relevant guidance in the slide. That's 14.1 of the 2018 cost assessment guidance and paragraph 6.36 of the contract specification. Another top tip on this slide. So where you're claiming line by line, you only need to state the bill line without the need to give the date and time spent for each item. When submitting a summary level claim bill, you'll need to give the dates and time spent as usual. So continuing on from that, if your assessable costs are under £2,500, then your claim should be submitted as an hourly rate claim only. Again, it would have to be submitted line by line. Voluntary assessed claims can be submitted with the profit cost at summary level or line by line with a schedule of work uploaded. And we put a link in the slide there, and that's a link to the transfer of claims assessed at court to the legal aid agency, and it gives you a lot of information on that process. And as I mentioned earlier, you can now just bill your cost if you're doing it line by line without having to put the date and the actual time on your schedule of work. CCMS used to not be quite aligned with how you were putting the lines in on your cases, but now they align. So if you've got items 1 to 10, that's how it will show when it comes through to CCMS. Okay, now we're going to move on to our next section, which is billing with council, and that's slide 10 in your slide pack. So there are no fixed fees for council claims in non-family cases. They will always be remunerated at hourly rates. As they are assessable costs, council's fees will form part of the single point of assessment and should therefore be submitted at the same time as the instructing solicitors. They're also included in the calculation to determine whether or not the total assessable costs, i.e. council and solicitors' profit costs and disbursements, meet the court assessment threshold of £2,500. In non-family matters only, council may opt for the instructing solicitors to bill on their behalf. If they do that, they do need to provide written confirmation that they're happy for the solicitors to claim it on their behalf, and that will need to be uploaded with your claim. You'll also need to set council's cost allocation to 0 because they're not actually claiming costs, you'll be claiming it for them, so that needs to be 0. Any payments on account to council will be recouped from them, and so you shouldn't have to deduct those costs when we paid your bill. Moving on to slide 11 then. If council are billing their costs separately, as always, they should be allocated the net costs of their claim. You'll need to arrange submission of your claims at the same time. Where council have been allocated costs, when solicitors submit their claim, CCMS generates a task called Council Submit Bill. And what this does, it prompts a request to council for their bill and holds the solicitor claim without it actually entering into our work queues for processing. So it just sits there waiting for council's bill to come in. Once council has submitted their claim, the task will be cancelled, and this will release both claims into our work queues for processing together. Now, the only issue we have with this is that if council don't respond to that council submit task within 14 days, it effectively times out. And what happens then is the solicitor's claim will enter the work queue, which unfortunately means that if council haven't actually submitted their claim by the time it gets picked up by one of our caseworkers to process, we'd actually have to reject the solicitor's claim because they do need to be assessed together. Moving on to slide 12 then. So you can actually check to see if council have submitted their claim on your side of CCMS, and how to do this can be found in an interactive course entitled Council Fee Reconciliation. The link is there in the slides. And finally, council must provide justification for any enhancement when they submit their claim. They can provide this in response to the default CCMS document request, or they can upload form CF1A, which has a section in there for enhancement, or their fee note with justification on it, or even just a separate sheet just giving that justification. But it is really important to make sure that if council are claiming enhancement, they do need to give us justification. Top tip on that slide. So again, before arranging to submit your claims together, it's probably a really good idea to check council's fee notes to make sure the work is covered by the scope of the certificate and they are claiming the prescribed rates. You may also wish to check that they are providing us with justification for any enhancement they are claiming. This helps to avoid rejecting council's claims, which would unfortunately mean your claim would have to be rejected also. So it's really important to make sure everything's there.
Hello everybody, my name's Stuart Bird. I'm a senior caseworker on the civil finance team based in our Liverpool office. I've been with the LEA since 2010 and work across a wide variety of civil billing areas, including non-family cases. I'm going to talk to you today about tips for billing enhancement and judicial review cases, and we shall begin with enhancements. So I'll be going through pages 13 to 17 in your slide pack, and I'll begin with slide number 14, which covers some general principles with regards to enhancement. On slide 1, we are discussing discretionary enhancement. So you may be aware that in family cases, we have an automatic minimum guaranteed uplift of 15% should the fee earner be member of certain family panels. That's not the case with non-family matters, and enhancement in non-family cases is claimed on a discretionary level. So it is for the fee earner to claim enhancement where it's considered justified and to indicate the level of enhancement sought, because that can be variable. Where enhancement is sought, the item requiring the exercise of discretion and the granting of enhancement must be identified. So it might be the case that all work on a case can have enhancement applied, or it might be specific items within that bill might have enhancement applied only. The fee earner will need to draw attention to the factors upon which you are relying to justify either the enhancement or the level sought. So some of the tips and suggestions we have address those points specifically. When preparing the bill for assessment, the narrative must clearly state the fee earner for whom the enhancement is claimed, as well as the basis for enhancement. Council should complete the enhancement section of the CF1A form, but we can accept enhancement justification being provided on a separate document or within the free text section of the billing area of CCMS. I'll now move on to slide number 15, which refers to the two-stage test the agency takes on assessment with regards to enhancement. Stage 1 of this test is to determine if enhancement is reasonable to claim in principle, and we do that based on one of 3 criteria. The first of which is the work was done with exceptional competence, skill, or expertise. So this may cover scenarios where the fee earner demonstrates unusually detailed knowledge relevant to the case, or perhaps they skillfully pursue an unusual or difficult legal argument. An example of unusual skill may be taking instructions and providing effective representation for a client who is a child, or seriously mentally ill, or otherwise very vulnerable. The second criteria would be that the work was done with exceptional speed. For example, substantial work was done at short notice because of urgent deadlines. That's then resulted in the fee earner being able to deal with other work scheduled for that day or that week. The third scenario would be that the case involved exceptional circumstances or complexity. So that may relate to the legal issues at hand, questions of conflicting expert evidence or other evidential issues such as challenging witness evidence, but it may also include the nature of the issues as they affect the client. For example, if the client's liberty is under threat. Stage 2 is to determine the amount of enhancement to be allowed and the work to which it should apply. So again, there's a number of factors which we would take into consideration. First of which is the degree of responsibility accepted by the fee earner. So one consideration could be the extent to which the provider has carried out work without recourse to counsel, whether that's in relation to analysis, planning the case, or the actual advocacy itself. For counsel, it could be that perhaps they've undertaken all of the advocacy in the case, and so there's greater degree of responsibility accepted by counsel, perhaps, in that scenario. Second criteria is that the care, speed and economy with which the case was prepared. So care may include aspects of skill with which the fee earner has carried out work within the case, and in particular, the care with which the fee earner has dealt with vulnerable clients. Speed will involve the same considerations as discussed in stage 1. Enhancement under economy would generally reflect the reward for the provider claiming less time than might otherwise have been expected. As you might gather, a lot of these factors do overlap, so it might be the case that exceptional skill feeds into economy because exceptionally skilled fee earner may take less time to prepare a case, for example, than might otherwise have been expected. So that factor may apply for the economy argument as well as the skill argument. The final criterion in stage 2 test is the novelty, weight and complexity of the case. Novelty, as you might expect, is where the case involves a novel point of law or legal context. Weight may refer to the volume of documentation or other material in the case, or the number of issues arising, or it could have the meaning of a particular importance of the case to the client. And where we refer to complexity, that involves the same considerations as we discussed in stage 1. So a lot of these factors will often overlap. So moving on to slide 17, you'll see some tips on satisfying this 2-stage test. So we often see fee earners point to their experience to support a claim for enhancement, especially with regards to the criteria of exceptional competence, skill or expertise. So we would argue that this is neither necessary nor sufficient, as we need to know how the fee earner's work in this specific case meets the enhancement criteria, rather than their past history, their general experience, the cases on their CV, and so on. We would want to know how that experience impacts specifically on this particular matter. Section 1211 of the 2018 cost assessment guidance states that there's no basis for arguing that proceedings within specific categories of law or types of proceedings will inherently satisfy the above criteria, such as that an enhancement should be payable in every such case. Each claim must be considered on its own facts. So occasionally we'll see that it is argued that a judicial review case is worthy of enhancement because of the type of proceeding that it is. And it might be argued that a judicial review matter is more complex than, for example, a contract arrangement case, and therefore that complexity should be rewarded with a grant of enhancement. We would argue that that's not necessarily sufficient, and we'd want to know how this particular judicial review case, for example, is complex or your work was urgent and so on. How does this particular case satisfy the 2-stage test rather than it automatically perhaps being complex because of the type of proceeding it is. The third suggestion here is that your grounds for enhancement should be sufficiently detailed so that a fair assessment can be made. For example, we would say it's not sufficient merely to state that a case involved exceptional competence, skill, or expertise. Instead, we'd recommend that you demonstrate how the case involved these factors. So this can be in the form of a short narrative, but providing, for example, counsel's written advice, the judicial review grounds in a JR case can assist in that. It can help the assessor get a fuller picture and provide context for the case so that we can get a proper view of the issues at hand, the complexity, perhaps the vulnerability of the client, and so on.
So moving on to slide 19 in your slide pack, in this section we'll be looking at billing where there's been a provider transfer. So for any case with hourly rates, either non-family or family proceedings, paid at hourly rates, the LAA will treat the claims as one single claim with one single point of assessment. Claims will not be assessed independently. The final acting solicitor will need to submit outcomes and one final bill for both sets of costs. It should be clear in the schedule of costs, including any disbursement, whose costs are whose. Top tip we have for you on that slide is when a provider transfer takes place, the cost limit doesn't automatically transfer to the new provider. The new provider will have to allocate the cost to themselves. The new provider will not receive payment of any payments on account or bills until the cost limit is allocated to them. So what will basically happen is, even though we'll process your payment on account, the actual payment will actually hold on CCMS until costs have been allocated. As soon as the costs have been allocated, CCMS will automatically then push that payment through. Okay, moving on to slide 20 then. Where the assessable costs are over £2,500, the firms need to agree whether the claim should be assessed by the court or by the LAA. They can't be assessed in part by the court and in part by the LAA, so it's either the court or the LAA. Again, it's all down to there being only one single point of assessment for all the costs incurred. Unlike our old paper billing system, payments on account will only be taken from the legal aid account they were paid to, and so these shouldn't be deducted from the previous firm's share of costs. Further guidance can be found on provider transfers, and there's a link there to a section on our website, and that's CCMS billing after a provider transfer. Just a top tip there. So first providers may find that they can't find a case when they do a search, even though it's assigned to them. It's likely because they have no cost allocation. CCMS won't actually recognise the case is assigned where there's no cost allocation. So if you have an inquiry, you can still submit a general or a case inquiry. You'll need to state the case reference, and then we can access the case and provide you with the information you require.
I'll now be discussing judicial review cases, and we'll be going through pages 21 to 26 in your slide pack. The most common issues that lead to a rejection or an assessment of a judicial review bill are those which relate to Regulation 5A. So under Regulation 5A, work on an application for permission is payable in accordance with our usual rules on assessment, where the court gives permission to bring judicial review proceedings. The defendant withdraws the decision to which the application for JR relates, and that withdrawal results in the court either refusing permission or neither refusing nor granting permission. The third scenario is where the court orders an oral hearing to consider whether to give permission or to give permission to bring a relevant appeal. And the fourth scenario is the court orders a rolled up hearing. The costs are payable in that scenario, even where permission is then later refused, or the case concludes prior to a decision on permission. So they're the four scenarios where work on application for permission is payable. The first scenario, the court gives permission to bring judicial review proceedings, is the most common, and the other scenarios, particularly the latter two, are less frequently seen. Where proceedings are issued but permission is neither given nor refused, for example, where the application for permission concludes prior to a decision being made and the aforementioned criteria are not met, then the solicitor will need to apply to the LEA for discretionary payment approval prior to billing. Where none of the four payment criteria arise, and most commonly this is a situation where the court has refused permission on the merits of the application, then the LEA cannot pay costs of work relating to making the application for permission. So a lot of the issues around assessment and rejection of bills often centre on this Regulation 5A point and whether the work of making the application for permission is payable or not. So on this slide, the top tip is that it is important that the bill narrative is clear on the issue of permission, because the assessor needs to know if proceedings were issued and the outcome of any decision on permission, so that we can come to the right decision and make a fair and proper assessment of the costs. So for that reason, it could be helpful to include within your claim copies of relevant orders relating to permission. So Regulation 5A does not affect the payment of disbursements, but does apply to council in the same way it applies to the work undertaken by the solicitor. So Regulation 5A, as mentioned, doesn't impact upon disbursements at all. So even if it's a court fee relating to the permission stage and permission is refused, that court fee is still payable because the disbursement in Regulation 5A does not impact on any disbursement. Regulation 5A does not apply to the earlier stages of work on a case. So stages of work prior to the application for permission stage. Most commonly, this would be investigation work. So work to investigate the prospects and strength of a claim. And that would include advice from counsel on merits. It would likely also include any work engaging in the pre-action correspondence aimed at avoiding proceedings under the pre-action protocol for JR. That work would not be impacted by Reg 5A, but of course it would be subject to our usual assessment checks, including if the certificate covers investigation work at the scope level. So the work that is considered at risk under Reg 5A is that of making the JR application. So that will vary case to case. So it's not going to be possible for us to give an exhaustive list of work that may or may not arise in that stage of work. But most commonly, it is things such as drafting the grounds of claim, instructing counsel to draft the JR grounds, preparing the claim form or the application for permission, and then the associated bundle of documents that go with that, which can be quite numerous and obviously will vary depending on the particulars of each case. Reg 5A does not apply to any work that relates to an application for interim relief. And on one of the later slides, we'll have a bit more detail on that and how that impacts on the claiming of work. So moving on to the next slide, slide 24. Because of the caveats and criteria of Reg 5A that we've just discussed, it can be helpful to include an addendum in your bill narrative to address any Reg 5A considerations. So, for example, if the defendant withdraws the decision to which the application for judicial review relates, and that withdrawal results in the court refusing permission or making no decision, it will assist us if you provide the court orders and make this clear in your narrative, because under the Regulation 5A guidance, that scenario, the work relating to the permission stage would be payable. But what we sometimes see is that the final outcome was that perhaps permission was refused. If it's not clear to us that the defendant withdrew the decision, and that is the point on which the courts made the refusal, then it might be the case that we perhaps reach the wrong conclusion on whether costs are payable. So it's really does assist us if you provide the court orders and then make any circumstances, or if there's any scenario that meets the caveats or the criteria for payment within Reg 5A, if that's pointed out as clearly as possible, that can really be helpful in avoiding the claim being rejected or perhaps assessed incorrectly. Likewise, there's a scenario where costs are payable if an oral hearing is ordered by the courts, but the wording of Reg 5A is clear that that hearing must have been ordered by the court rather than taking place perhaps as a result of being listed on behalf of the clients. Likewise, an oral hearing must have been ordered by the court rather than having been listed as a result of an application on behalf of the client for payment be recoverable under Reg 5A. And that's because of the wording of Reg 5A is explicit that an oral hearing must have been ordered. So a clear reference to this in the narrative, along with a copy of the order, will be helpful to us, because it is commonly the case that we can see that an oral hearing has taken place, but there are scenarios where we're unclear if it's been ordered by the court. So that can lead to a further information request or perhaps a rejection rather than the bill being paid first time, which is what we want. So the next slide, slide 25, just has some pointers on discretionary payment aspect. So where permission is neither given nor refused and the criteria for payment are not met. So for example, where the application permission concludes prior to a decision being made, providers will generally need to apply to the LEA for discretionary payment. This request for discretionary payment must be made before you submit your claim on CCMS. Failure to do so will mean that we will have to reject the claim. So what we sometimes see is that providers are aware that they need to make a discretionary payment because permission's now been granted and refused, and none of the criteria for payment arise. But they'll do this by perhaps adding an addendum in the bill narrative when they submit the claim. It can't be considered by the caseworker who is assessing the bill. It needs to be done prior to the billing stage. So we would advise that you make an application for discretionary payment before billing, and you do so via a case inquiry on CCMS. And you can select the relevant drop down from the list. So the request type is JR discretionary payment request, and then that will get filtered through to the appropriate team to make that decision. The final slide in this JR section, slide 26, touches on some issues of evidence. So as you might have gathered, the bill narrative is of particular importance in judicial review cases. not only because of the Reg 5A considerations, which we've been over, but the assessor will need to know the details of the decision under challenge. And it's important that we have relevant dates provided for significant points throughout the chronology of the case. So, for example, we will need to know the date of the decision under challenge, date of any letters before action, and the date of any responses received from the defendant. In particular, if there's any offers to settle, any offers at resolution, then the dates of those offers would be significant because they can impact on scope issues and so forth. Whilst it's not mandatory, it's often useful to provide all letters before action, copies of any responses received from the defendant, copies of counsellor's advice, if applicable, as well as copies of any orders, particularly those which relate to permission, because this can assist the assessor in making fair and proper assessment of the claim. Hopefully reduce the need for us to go back and request any such further information in the future. Likewise, counsel may also wish to provide copies of any written advice, especially if perhaps the preparation times are higher than might normally be expected. The case is particularly complex. The complexity of the case is perhaps one of the reasons why enhancement is being claimed. It can be useful in that scenario to provide copies of the written advice, the JR grounds, or similar to evidence the work undertaken, so that you perhaps reduce the chance of document requests to reject or perhaps an assessment.
Okay, moving on to slide 28 then, just a very short section on disbursements. So generally in non-family cases, there are far less disbursement claims than in family cases, but obviously there are some. So there's things like interpreter costs, surveyor costs in disrepair claims and that sort of thing. Our requirements are exactly the same as they are for family proceedings, and so we thought it'd just be useful just to go through the main points. So all disbursements of £20 or over, inclusive of VAT, must be evidenced, and we've got a link there. It's 10.2 of the electronic handbook, and that covers our requirements for disbursements. So if a disbursement is under £20, we don't require evidence. However, we would need an explanation of what the disbursement relates to. We just need to be able to see that because we need to determine if the cost is reasonable and it's in scope. So, for example, if you have a parking fee of £7 that doesn't match any attendances at a hearing, we need to know what the fee was and why it was incurred. All disbursement vouchers should contain the client's name and the date of work, simply so we can match it to the case and we know it's the right disbursement for the right certificate. For experts' invoices, so they should contain the expert's name and their specialism, the hourly rate being claimed, and a breakdown of each item of work and the hours taken for each. We'll need the address of the expert, and if they are claiming any travel costs, we'll need to know where they're travelling to and from and how many journeys were taken. If they've travelled by public transport, we'll need receipts on copy tickets should be provided, ideally uploaded with the invoice in the same document. Any overnight accommodation, we don't see it very often at all in non-family cases, but I'm sure it crops up now and again. So yeah, overnight accommodation should also be evidenced with an invoice or a receipt. Please refer to slides 30, 31 and 32 in the slide pack for additional links and how to contact us.